So it is 11 a.m. My name is Jordan Walker. Thank you for joining us this morning to talk about the ITC Michigan Grid project. It is 11 o'clock, like I said, so we're going to go ahead and get started. It should last about 30 minutes. If you have any questions, feel free to use the chat. We may not get to them until the end of the presentation, but we will answer your questions. And with that being said, I am going to go ahead and get started. Again, today we're going to be talking about the Michigan Grid project, which is several power lines and some other substations being built in Michigan as part of the larger project. But before we get into that, I want to talk about who we are. For those of you that haven't met us yet, we've had a couple of webinars, a couple of seminars thus far, and we plan on having more in the future. So we've met quite a few landowners already, but some of us might not know who we are. We are a eminent domain only law firm, we being Sever Walker Padgitt. We are not with ITC. That is a question that we get a lot, and people get our letters and they aren't sure who we are, who we work for, who we're here on behalf of. We are a landowner-only, eminent domain-only law firm. We do not work for ITC. We have never worked for ITC. We have never worked for a power line. We have never worked for a government entity. We are a landowner-only, eminent domain law firm. We work on behalf of you, the landowner, faced with this acquisition by ITC. So we like to get that out of the way up front because sometimes there's some confusion on who we are and what we're doing. Again, we are eminent domain only. This is the only type of law that we practice at Sever Walker Padgitt. That's the only type of law we've ever practiced. It's the only type of law I've ever practiced as an attorney since I became one 12 years ago. We have, as a consequence, because we are only eminent domain, because we are landowner only, we have done hundreds of pipeline cases, hundreds of power line cases, utility projects, road projects. We've done so many over the years. I personally have represented hundreds of transmission line clients, not only in the Midwest, but elsewhere. So as a consequence, because we've done this so much, we know what to look for. We know how this works. We've experienced a lot. We've learned a lot, of course. And what we're here today is to relay the information that we have learned over the years to you. So when ITC comes in and starts making offers to you for your property, you are equipped to handle it. You know what to do. You know what to say, what not to say, how the process works, and you'll be better equipped when they come in. So that's the goal of today and what we're trying to relay to you guys. Some of you have already been to some of our webinars already, and thanks for coming back. It's going to be a pretty similar presentation to our last one. We are going to talk a little bit about the where we are in the process, the Michigan Public Service Commission. But this is going to be pretty similar to our previous presentations. The big difference is that in our previous presentations, we were just beginning to acquire clients and acquaint ourselves with how ITC is handling these projects. Now that we have a significant caseload of clients, of landowners in Michigan that we're helping out, we've seen the documents from ITC that they've been presenting to landowners. We've seen how they're operating generally. We've like I said, acquainted ourselves specifically with this project and what ITC is doing on the ground. We've learned a little bit, so we will share what we've learned on this project specifically as well. I want to start with the process, and this is utility projects in Michigan generally, and where we're at in the process. So in order to build a project like this, which is actually two different projects, the Helix-Hipple power lines and the Nelson Road to Oneida transmission line, two separate transmission lines, part of the same larger Michigan Grid project. In order to build these projects in Michigan and in most states, it requires a regulatory approval. And in this instance, ITC has gone to the Michigan Public Services Commission to seek that approval. They are in the process of attempting to get that approval. They do not have it yet. The expectation is that they will get that that approval here sometime this year. I would guess towards the middle to the end of the year, based on the schedule that I've seen on the website, the Michigan Public Service Commission website. And I should note that there are two websites that might help you out, might assist you if you're looking for more information. The first one is actually listed there on the slide, and that's the mifuturegrid.com. That is ITC's website. And normally I don't ask landowners to go to the utility to get information because it's not always reliable. However, this information we found is reliable, and that is the maps that ITC, the maps of the projects that they're trying to build, that ITC wants to build. They have detailed maps on ITC's website. You can go to it. You can find out where your parcel is in relation to these lines. And this is more for people that haven't quite received an offer yet, aren't quite sure where they stand on the project, where their property is situated relative to the proposed routes. So if you're looking for more information on that, a good resource is the ITC website for that information specifically. If you're trying to learn more about what's happening at the Michigan Public Service Commission, I would go to the Michigan Public Service Commission website. They have a e-docket, a online docket that you can access at their website. Just Google Michigan Public Service Commission. It'll take you right to it. Go to the e-docket, look up the project, and you should be able to find the docket, and that'll have everything that's going on before the Michigan Public Service Commission right now. As we sit, they are still determining route location. There are a couple of route options for these projects. So there's a primary route and there's an alternate route. So things aren't quite set in stone as we sit here today, but things are moving along before the Michigan Public Service Commission website on the docket. So it is moving along. It's moving at the standard pace you'd expect from a utility commission approval process. So again, we'd expect that approval sometime this year, summer, fall, possibly even winter of this year. But regardless of where they are in the process, they are making offers. ITC is coming out to landowners and making offers. Now, that doesn't mean that they've made an offer to every single landowner on this project. In fact, I'm sure there are a large majority of folks who have not yet received offers. If you have not received an offer, a proposal from ITC, and you're concerned, you think something is going on, ultimately, what I tell people is if ITC wants your land, they have to come to you. They have to give you a proposal. They have to as a matter of law. And they are going to. They will make their presence known. For those of you that do have offers, you're aware that the right-of-way agents come out. They make the offer. They want to have follow-up meetings. They want to keep talking. So just, folks sometimes call me. They're concerned. They're concerned they're missing something, or maybe something hasn't happened. Just remember that they will come to you if they need your land. And a good way to find out is if your land is on the route is to go to that website and see if your property is affected. Now, you'll know it's affected if they come to you and make an offer. And once you get that offer, it'll show exactly where the line is going on your property, along with the easement they want and the compensation offer itself. So that is the process in Michigan for the acquisition. So I've already mentioned eminent domain. That is the area of law we practice. And I'll just touch on what that means and what it means relative to this project specifically. So condemnation, which is the procedure of exercising eminent domain. So eminent domain is the power of an entity to acquire private land and put it to a public use. It's most often seen with road projects, highways, interstates, the Michigan Department of Transportation, any governmental entity, that wants to build something and put it to a public use. Airports, railroads, and in this instance, utility lines, pipelines, these types of public works projects. These come along with eminent domain, the power to acquire this private property to put to these public uses. So basically, they have the ability to acquire it. And whether you don't want it to happen or not, ultimately, they have the ability to get it
and put it to that public use. So that's the power of eminent domain, the power of public entities, usually governments, in this case, in ITC, the power of them to acquire private land and put it to a public use. And transmission lines are a public use, at least this one is, because it is serving the public at large. I understand that for a lot of folks that are not fans of this project, not fans of any project that requires the acquisition of their private land, that is a hard fight to make. I will say that stopping these acquisitions is very difficult. Stopping eminent domain is very difficult. If you don't want this project to happen, if you don't want this power line to go through your property, what I tell people is the time to argue that is before the Michigan Public Service Commission, is to go onto the online docket and let them know your issues, let them know your complaints. I believe we might be past the deadline for landowners to intervene on the schedule or intervene onto the docket, and anyone to intervene on the docket and to challenge the project. You may be able to get leave to do that, however. But in any event, what we tell people, and that we're not trying to discourage people from voicing their issues with this project, far from it. This is just the reality that we exist in, and at eminent domain, that is the legal process to acquire your private land, your land specifically. If you go into eminent domain trying to raise those arguments that this project shouldn't be built, or it's not necessary, or it's not a public use, it's going to be a very, very difficult argument to make at that point. So stopping these projects is usually best reserved or best exercised at before the Michigan Public Service Commission. So back to eminent domain. They will have the ability to acquire this land and put it to this public use. They will have this eminent domain authority. And why that's relevant is that it changes the dynamic of the negotiation between you and ITC, because they have this cloud over the negotiations, this ability, this leverage to acquire your land, which they like to use against landowners to try to drive down the price. It changes the dynamic. It's not just selling your property to your neighbor or somebody who wants your private transaction. They have this power, they have this leverage. And so it's up to you, it's incumbent on the landowner to even out the power dynamic and get it back on your side. And there are ways of doing that, and we'll talk about that. But it's important to remember, because they have this ability, and they like to remind landowners that all the time that they do have this ability. It's something that's very often relayed to the landowners. And that's in an effort usually to scare or intimidate or try to coerce landowners into selling their easement for bottom dollar prices. It's important to remember that they have this ability. You have the ability as well to change the power dynamic, add some leverage to your side, and certainly get a better deal. And we'll talk about that. So the condemnation process in Michigan generally, and we are going to talk about this process, but I do want to say that just because I'm talking about this process doesn't mean your case is going to go to eminent domain. It doesn't mean that we can't reach a deal with ITC that gets you what you want with a better easement, with better money, without going to eminent domain. This is just an explanation of what would happen if your case got to that point. The first step is surveying. They've already done quite a bit of surveying on a lot of these parcels. So this is the first step in the process. And I tell that because it's usually the first on the ground visualization of the route that you're going to see. The next step is appraising. We have not, as far as I've seen, we have not gotten to the appraisal step of this process. I haven't heard of any appraising going on. There are certainly offers being made, but there's been no appraising done by ITC. And I wouldn't expect that to happen until we get get further into the process, get further down the docket, the Public Service Commission process. But they do have to appraise your property if they want to condemn your property. They have to first appraise it, and then they have to then give an offer. Now, they are giving offers. So what ITC is doing is they're kind of skipping the appraisal step for now and jumping straight to offers and it's called a written good faith offer. So they're making offers, but they aren't necessarily making the written good faith offer that's required by law. They're trying to go out and get these this is what utility projects do. They like to do this kind of pre-condemnation offer
process where they try to negotiate without getting into the condemnation or pre-condemnation process. So they are making offers, and we are helping out landowners as we speak with folks with offers. So those are already on the ground, but they aren't necessarily the written good faith offers that are required by law. But regardless, assuming we get down the process into the timeline, and they are starting to ramp up the condemnation or get close to eminent domain, they'll make a written good faith offer, and then if that deal is not accepted or approved, if you can't reach a deal by hook or by crook down the road, eventually, and this is down the road, of course, eventually they're going to need the land. They'll file a condemnation complaint which is an eminent domain complaint in the county circuit court where the property is located. And with that, they do have what is called quick take ability. Quick take ability grants them the ability to access and gain the rights to the property at the onset of the litigation in exchange for depositing their written good faith offer with the court. This is called quick take. It is fairly common in states to have a quick take authority ability for condemners, power lines, pipelines, government entities to acquire the land early in the condemnation process, allow for a preliminary compensation amount to be determined that acts as a deposit for that access that ITC will get. And with the rest of after that happens, the rest of the condemnation is basically over final just compensation, or ultimately what you are entitled to for this acquisition. Eminent domain is a significant power that governments have, that power lines have, that pipelines have. But with that power comes a responsibility, and the responsibility that they have is to provide you, the landowner, with what's called just compensation. This is codified in the Fifth Amendment, Bill of Rights, federal constitution, and each state constitution as well has an amendment or a statute rather that demands just compensation is provided to the landowner. So that is a right that you enjoy as both a Michigan landowner and a United States landowner. So that's the condemnation process. We talk about it, but I think I just want to stress right now that we are not at eminent domain. We are not close to eminent domain. We are at the early stages of acquisition where offers are being issued by ITC. The reason why we talk about this is that this exists, and this exists whether it's now or in the future. It'll be in the future. It is part of the negotiations. It is a pall that hangs over the discussions, and it's something that the landowner needs to be aware of in this process. So we talked about the offers that are being sent, and offers are being sent, but they are, of course, like I said, not being sent to everybody at this time. This is a big project with a ton of landowners. It's going to take them time to get to everybody and make these offers, but they are being issued to landowners. So what I tell folks when they get this offer, because there's a certain way to handle these negotiations and there's a certain way not to handle these negotiations. It's important to remember that you're dealing with right-of-way agents. Right-of-way agents are contracted individuals. We deal with them all the time in many different states. They're contracted by ITC to come out and sell you on the idea that what they are offering is fair. That is their job. That is their goal. When they come to you and they say, here's the offer, they're going to tell you, or try to tell you everything about how great it is and how fair it is and how it's, how you're entitled to it. Or they might tell you that if you don't take it, they're going to seize your property with eminent domain. They do a lot of things, some ethical, some not. So what I tell folks is that, there's a way to handle these negotiations, and there's a way not to handle these negotiations. The first recommendation I make to landowners is that they should insist that the right-of-way agent communicates via email only. The reason why that's important, or text or email. In other words, make sure there is a transcript of your discussions with the agent. The reason why is that verbal conversations, they want to have in person. They want to come meet you. They want to talk on the phone. They want to have these unrecorded, not off the record discussions, because then they can say whatever they want. And there's no record of the promises they made to you. or what they said about the offer, what they say the easement says, or what they say the ITC will or won't do. Verbal promises mean nothing in this scenario. They mean nothing for your easement. They mean nothing for your property. The conversations that they have in person, they're not bound by that. They will say they never said it down the road. They mean nothing. So if you're going to have discussions with the right-of-way agent, which I don't generally recommend you do without first talking to an attorney, I would say have all conversations via email, via text. So there is a writing. If they want to promise something to you, whether it's money or an easement right or an ITC, or that they're not going to do something to your property, they will do something to your property, then make them put it in writing. Make them say, ITC will do this. But with that being said, going to my next point, I don't generally recommend that you jump in and start talking to them. And the reason why is that when you get this offer, this is not a traditional situation that a landowner finds himself in. This is not common, that where somebody comes in and wants a transmission line easement on your property. It isn't something that a lot of landowners know how to do. And so when you get this offer, you might instinctively start throwing out numbers or compensation that you think you're entitled to, or easement protections that you think you should get, or that you think the easement's okay, or you might say anything about what you think is fair or what's not fair. The reality is that you don't know, because this easement, as we'll get into, is a legal document that is full of legal jargon that, as we'll discuss, requires a lot of work. And what they're proposing to you is not a fair easement as we sit. But beyond that, going back to the money component, if they come in and start talking about money, again, you might instinctively say, oh, I'll take X, or I'll take Y. So if they come in and offer you $50,000, you say, well, I'll take 65, I'll take 70, or something like that. Not knowing that you might actually be entitled to a lot more than that. And remember how I talked about keeping things on the record. One thing that right-of-way agents will do is they will take notes of your conversations that they have. They'll write down what you're willing to accept if you haven't already put it in writing yourself. And that'll be there, and it'll move with you throughout this process. And then they'll know what you originally said the property is worth, or what you think you're entitled to. And that, let's say in that scenario, you were offered $50,000. And you said, I want 70, but you come to me and I say, whoa, you're actually entitled to 150 or 200. You already told them you'd take 70, and they know that, and that's going to stick with you. It's going to go to the next right-of-way agent. It's going to go to their attorneys. It's going to stick with you. It's going to be part of your file with ITC. So, and the reality is that a lot of, you're negotiating with somebody who might not even be able to get you that anyway. So you might be wasting your time and hurting your case in the instance by jumping into these discussions and starting talking with right-of-way agents about this type of information. It's important to be very careful with what you give them and with the information that you provide to them, because they are trying to get information from you while also trying to get you to accept their deal. So what I tell people is, as soon as the offer is received, or as soon as they reach out to you about making an offer, first of all, insist that they send it via email, or if they want to mail it or fax it, whatever's easiest for you, that's fine too. But what I tell people is to respond, thank you, I will review this and get back to you in a week. This is a perfect response because for several reasons. One, you're not blowing them off altogether. You're giving yourself a week to look at this, which is plenty of time to contact me in the interim, and I can tell you what I think. So you're not totally blowing them off. You're not, but you're also, being reasonable, giving yourself some time to review it. They're not going to, they're not going to move you to eminent domain or anything like that. But if you're asking for a week, you have plenty of time. But this gives you some time, and allows you to form a plan for what you want to do and how you want to respond. It's important not to react to these offers, but to respond. And to respond intentionally with what you want to do, and develop a plan for how you're going to handle this case, how you're going to handle this process. If you want to jump back in and start negotiating, great. Nothing's going to stop you from doing that a week later. You're not going to be put behind the 8 ball.
You know, and you'll have a week that they shouldn't bother you in that week. You know, if you don't respond altogether, they're going to keep bothering you. They're going to keep bugging you. They're going to stop by whether you like it or not. They're going to keep coming after you until you respond. This is what they do. If you ask for a week, they're not going to bug you in that. They'll allow you a week, and you can figure out what you want to do in the interim. So this is a response that we advocate for all of our potential clients, all the landowners that are affected. In that week, then you can contact an attorney for a review of the case. We, for example, will do that for free. I will do it for free. I will look at your offer for free and tell you what I think about it. What is probably going to happen, given that we've seen these offers, quite a few of them at this point, and they're all identical to one another. They follow the same format, same structure, the same, you know, the easement is identical besides the property identification. What I'm going to tell you is that this offer is insufficient and this easement needs to be changed significantly. Because, again, they're offering the same thing to your neighbors. They're offering you, at least structurally, the same. There might be some price break or differences. There might be, and of course, the property identification is different and the name is different, but everything else is the same. It's the same document that they're presenting to everybody. So I can tell you now that when you get that offer, it's not going to be the right amount of money. It's going to be insufficient for that reason. And I'll tell you right now, that easement is going to require quite a bit of work. It's going to need to be changed, and we'll get into why that is here in a bit. Again, final point, avoid in-person discussions and negotiations. These are not there to benefit you. It is there to benefit them. That's why they advocate. That's why they always want to meet in person. They will definitely want to do that. So avoid that. Keep everything on the record and avoid jumping in before talking to somebody else. What not to do. And we kind of already touched on the first thing. Don't jump in and start talking about value. You can always do that when you want, but don't do it at least immediately. Talk to an attorney. And then if you want to handle it yourself, which I don't advocate, but if you obviously have that right, at the very least, you know, you're giving yourself some time to develop a plan for what you want to do. There's always time to negotiate if you want to do it yourself. But I would not recommend doing that. At the very least, consult with someone else. Do not enlist an appraiser. That's one thing that a lot of folks want to do. They say, well, my land's worth more. And this is a big project. This is a big company. I need to get my own appraisal. You do not need to get an appraisal yet. And generally what I tell folks is you don't need to get an appraisal until you are at litigation. And you shouldn't want to. Why? Because eminent domain appraisals, first of all, and this would be an eminent domain appraisal, are very expensive. They are not cheap. So if you're going out there and spending that money, you should absolutely be, it should absolutely be necessary and worth it. And in our view, it's only necessary when you're proving your case for compensation, and that only happens at condemnation. So, and we'll talk about costs and stuff like that here in a bit, but you don't need to go out and spend money if you don't need to. I tell that, and I'm very cost conscious on behalf of my clients. I don't like them spending money if we don't need to. And that is something that you might not need to do, and you probably won't need to do. And if you do, I'll tell you that, but it'll happen much further down the road. And, and that's only if it gets to that point. Again, don't meet in person. Do not take promises at face value. This is something we hear a lot. They will, right-of-way agents, again, they'll make all sorts of promises about what's going to happen on this project, and those verbal promises mean nothing. All that matters is what the easement says, what the document that you're signing says, what the protections in that document say, what they're allowed to do, what you're allowed to do. It all depends on what the easement says. We'll get into what an easement here in a bit, but just do not take agents' promises at face value. Do not assume that their interests are your interests. They are not. They're trying to build a power line for as cheap as possible. They want to get from A to B without spending, by spending the least amount of money they can. That is their goal, and they are not concerned. Everything else, they can say that they want to be good partners and good stewards, and ultimately that might be the case, but you can't assume that that will be the case.
you will better serve yourself if you assume that if you protect your interests and not assume that they're going to look out for you at any point now or in the future. Finally, do not make a rush decision, but also don't ignore it altogether. I have folks that when they get this, they put it to the side, and they don't address it at all, and all of a sudden they end up in court, and they might not want to be there. They probably don't at that point. So this is not something you just want to leave on the back burner forever, and it's also something that you not want to make a rush decision and leap into an acceptance of their offer, or jump into immediately taking what they're offering or anything like that. So it's kind of two different competing interests, but don't make a rush decision, but also don't leave it stagnant forever, and because you might end up in court when you don't want to. Okay, so we talked about offers, and we didn't really talk about what they're offering to acquire. What do they want from you? What is ultimately the document that they want? What are they trying to get? They want an easement from you, a permanent easement, I should say. And an easement is basically a deed, but you're not selling the entire property. You're only selling the right to do what the easement says, where the easement says, and when the easement permits it. So it's a document that'll show up on your title forever. It is a forever document. And again, to think about it this way, if you were selling your entire property, you'd be selling 100% of your land. So your fee simple ownership interest, if you were just selling your property to somebody else, you'd sell 100% of your entire property. An easement is like selling 95% of an area of your property to somebody else, depending on how, it's 90, 95, depending on who you ask. You're basically selling an area of your land for a very specific purpose, or it should be a specific purpose. And that brings me to my next point. One question I get a lot from landowners is, what are they allowed to do on the easement? What am I allowed to do on the easement? How do these rights interact? Because you still own the land. So when you sell an easement to somebody else, 2-acre easement, say, and you own, that 2 acres is still titled in your name. You still own the underlying land. They just own an easement over that area. But the question I get again is, am I allowed to farm that area? Are they allowed to exclude me from that area? What are they allowed to do? What am I allowed to do? And the answer to that question is always, it all depends on what the easement says. And that's why the easement's the most important document you're going to have. They're going to present it to you. It's going to have all this legal language in it. It says what they can do. It says what you can do. And that is going to be the most important document. And it all depends on what that easement says. So if you want to know if you're able to farm on that property again in the future, my response is it depends on what the easement says. Are they going to be allowed to put a pipeline in if they want? I'm going to say it all depends on what the easement says. Are they going to be allowed to access the property not only using the easement, but using the rest of your land? It all depends on what the easement says. So it's crucial then that document is carefully worded, carefully crafted, and drafted in your favor as much as it can be. Again, this is why the verbal promises mean nothing, because 10 years from now, when that easement is still there, and they're running roughshod over your adjacent property, they're adding another power line to it, and you say, well, wait a minute, I met with right-of-way agent John 10 years ago when we sat in my living room, and he said they're not going to build any other lines on my property, and they're not going to access my property from all 4 corners of the property line. And the response is, again, that verbal promise means nothing. That was a conversation between you and the right-of-way agent that was not reflected in the easement, so it doesn't matter. It means nothing. It's a hearsay discussion about what their rights are. So again, that's why it's imperative that the easement is crafted appropriately. And remember, of course, easements are forever, or at least this easement will be. The easement lasts, it sticks with the property, it runs with the land. When your kids inherit this property, the easement's going to be there. When their kids inherit the property, it's going to be there. If you sell this property to somebody else, it's going to be there. It's always going to be there unless it is extinguished and abandoned off the property, which does not happen that often. So remember that their easements are diamonds. They last forever. It'll be recorded on your deed. It'll show up at all times unless it's been extinguished. So just remember that. So it's not just about protecting this land for you. It's about protecting this land for your kids and their kids and so on and so forth. So we talked about easement language. I want to talk about money because there's two components to your acquisition. There's the easement and there's the money. What does the wording say? What is is the money appropriate? Some folks care about one and don't care about the other. Some folks care about both or prioritize one or the other. But and that depends, of course, on your just individual priorities. But both are generally important, as we found. What I tell people is that a complete compensation package, and I've seen the offers, they are deficient. They are not offering enough money. A complete compensation package should include a proper price per acre for the land to be acquired. That is important, but I want to let you know that it's not the most important. And the reason why is that, you know, if the offer is $6,000 an acre, $7,000 an acre, and you say, no, wait, I'm entitled to $8,000 an acre or $9,000, and that's it's not nothing, of course, but that's a discussion that a right-of-way agent wants you to have because you're talking about pennies. You're talking about on a 2-acre easement, you're talking about $4,000 in difference. That's a discussion that the right-of-way agent wants to have every single day because that is not a lot of money, and it's something you're playing into the game of discussing price per acre. You're avoiding the larger discussion, which we'll get into here in a bit. But they want you to have that discussion. And don't get me wrong, getting a proper price per acre is important. That's part of our negotiations. But it plays a smaller role than what we get into in a little bit, and that is residual damage. So of course, you have the proper price per acre. You're entitled to a proper price per acre, and that includes, you know, if there's a mining possibility, or if you have some sort of operation, mining, gravel operation, anything like that. You know, that needs to be considered, or the potential for that into the price per acre. You need proper payment for crop or timber damages. That's important, of course. They're going through a lot of timber and a lot of rural properties. That's going to affect crops both during construction and in the future. You should have a proper payment for that. Important to note, you'll want either a prepayment or a strong clause in your easement agreeing to remediate the land caused by construction or after construction, rather. You know, there's going to be some heavy equipment that's going to come out onto your property, and that, you know, there's going to be compaction. There's going to be issues. You know, they might affect irrigation or drain tile. You know, that is important that you get either prepayment for those damages or something in the easement that is strong in its remediation or of those issues. We've seen issues where they build these things and they don't segregate the soil. The topsoil gets mixed with the subsoil, and therefore and then when they put it all back together, you get worse soil as a consequence. That is consideration. And then a proper consideration of all damages: field tile, irrigation, compaction, as I said, debris, flooding issues. If there's livestock that needs to be segregated from the line, that requires fencing, additional fencing, you know, things like that. Really, anything that they're going to damage, physically destroy, or tear down needs to be considered in your compensation. And then finally, this is the big one, and that is residual damage. So residual damages are basically anything that is a damage that affects the rest of the parcel, not necessarily the 2-acre easement or whatever size easement they're acquiring. Residual damages can be caused by a lot of different reasons. The big one is that generally properties with power lines the entirety of the property sell for less money than properties without power lines. You know, whether it's cutting right through the middle and affecting your farmability of the land, or people just don't want to be near power lines and have, you know, fears about them.
whether they're justified or not, the reality is that people generally will pay less for property that is encumbered with a power line easement than one that is not. And right there is the remainder damage. And if you're talking remainder damage and you assign a 10% impact on the rest of the parcel, on a 40-acre tract that's valued at $10,000 an acre, that's $40,000 just right there. And that's a low estimate on for the impact. Right there, that's why talking about price per acre, while important, is not as important as talking about residual damage. Other examples of residual damage, if there's a house near the power line, that house, depending on how close it is, potentially can lose value by being closer to the power line, by walking out your front door and there's a huge transmission line in your front yard. That has an impact on the structure's value. If you have a dairy farm or livestock and you're concerned that there are some studies, there's some discussion about how transmission line affects dairy production. These are things that fall underneath the residual damage umbrella that you are entitled to if you can prove them. And it's something that can be significant in some cases. If you have a gravel or some sort of mining operations then this prevents you from accessing it or makes it more difficult or impossible to access that or have that operation. That's something that would be a huge issue, of course. So it can come in many different forms, but we've seen them all. Well, I'm sure we're going to see new issues in the future. We're always seeing something new, but it comes in many different forms. In any event, you are entitled to it if it exists and if you can prove it. And that's in addition to any bonus payments that are offered by the utility. From the offers we've seen, ITC is offering like a very paltry bonus payment. It's a document review amount. It's de minimis. It's like $1,000. Well, it's around, depending on how big the offer is, it's a small amount of money. But these are all amounts that you're entitled to in addition to whatever they're offering ITC is. So keep that in mind. This is a complete compensation package and something that each landowner should be trying to accomplish. So we talked about theoretical easement problems. Let's talk about actual problems that we are seeing on the ground with ITC. Right now, we represent about 20 different parcels on this project. We anticipate to represent quite a few more as more offers are being issued. We've seen the offers, we've seen the compensation, we've seen the easement. Here's what we are seeing on this project specifically. Low compensation package. They are not offering any residual damage at all. I haven't seen any offer to that extent. I don't believe any crop damages at all that we've seen. It is about as bad as it gets as far as what we see across, we've done this in many states. I've represented hundreds of landowners on huge power line projects across the state, in Illinois, Georgia, Iowa, et cetera. And this is, utility companies are vary in their favorability or the types of offers they issue, but these are about as low as it gets. There's no consideration for impact on the parcel. It's kind of a one-size-fits-all offer that's being issued to everybody. So it's low, and I'll tell you that right now. You're not going to be happy or satisfied when you get it, and you shouldn't be. And it's until we see that change, I have no reason to believe it's not going to stop. So the money's not there. We know that. The easement, the document they're proposing, it also, as I said earlier, needs a lot of work. They're asking for broad access rights. They're asking for the right to add more than one power line if they want to. They're asking for the right to add fiber optic cable into the easement. And what that means is that down the road, if let's say ITC wants to make a little extra money on these easements, they can go to your cable company or whoever and say, hey, we got these easement rights. We have the ability to add cable if we want. How much do you want to pay us for our easement right that we own, that we can assign to you via the easement that these landowners sign? So they'll make a little money off that, and you won't get anything because you sold that right to them, and you sold that right for them to do it. So they're sneaking that stuff in. That's something we see a lot.
That's a fairly common thing that utility projects like to sneak in. Actually, all three of these are fairly common. Broad access rights, more than one line. That's a big one. A blanket easement is what it's referred to, where it blankets the property and they can access it from any direction, wherever they want, not just the easement, outside the easement. We're seeing that. And then they can add 1, 2, 3, 4, 5, 6, as many power lines as they want on any portion of the line without giving you any subsequent compensation for it because it's already in the easement itself. And then also the ground restoration language requires some work. And then another point that I didn't add into here is that there's no specification on where the poles are going, at least not right now. So, there's no, while they have the overall map of where the line's going on your property, they don't specify where the poles are going. And it's likely that they don't know yet, but that's not your problem. And you need to know that. And so whether that takes a while for them to determine that, you deserve that specificity in your easement so that they don't come in and say, oh, never mind. And instead of putting it in the pole in some recreational ground, some timberland, they put it right in the middle of your pasture or your farmland and say, well, we changed our mind. So that's something also that they have not been doing and that we are, of course, asking for. And that leads me to my next point is that because we already represent landowners in this, because we're already working on behalf of landowners, I've already gone through and I've redlined this easement and made changes to it and sent them over to ITC and said, this isn't going to work. We're taking this out. We're taking this out. We're taking this out. You need to tell us where the poles are. You need to do this. You need to do that. The cable's gone. The line's gone. Access, easement only. These are things we've already done. So, and these are things that we can do for you, of course, if you're interested in our representation. So it's already something that whether you're working with us now or in the future, we're already doing the work on your behalf if you end up signing up with us. So, which leads me to my final slide, and we are running long, and I apologize for that. And we'll take some questions here. I just want to talk briefly about our firm and how we operate. If you are interested in helping us out, or if you are interested in working with us, rather. So attorneys generally work on two types of fee arrangements. They have contingency fee agreements or hourly agreements, and that's general. There's plenty of different agreements between clients and attorneys, but those are the two big ones. And an hourly agreement, usually with a retainer, where they bill $500 an hour for the work they do. Every hour they put into your case, they bill you $500 or whatever their billing rate is. Usually that requires a retainer up front. So they ask for $5,000 up front that they then bill against. So a $5,000 retainer, you have basically 10 hours of work from that attorney. Once they exhaust that 10 hours, they'll say, hey, we need some more money. We've exhausted the retainer. We're going to keep billing. And for every hour we bill, we're going to bill you $500, whatever. That's one way of doing it. While we do that on some cases, it is a rare method for us because usually landowners don't want to do it that way. If that's something you're interested in, we can certainly do that. But most of our clients prefer the contingency fee agreement, where our fee is contingent on how much more we get than what is offered by ITC. So in our instance, our standard contingency fee is that we collect 1/3 of any amounts of the compensation that we receive on your behalf over and above the offer. So your offer is $50,000 as an example. You hire our firm, we get you $100,000. Our fee is 1/3 of the 50 that we add to the case, and it comes out at the end so that you don't have to come out of pocket. But here's another important fact about Michigan, and this is unique to Michigan. Attorneys' fees and any costs are reimbursable in Michigan. I'll say it again. Your attorney's fees are reimbursable in eminent domain at Michigan. So as a consequence, our negotiations with ITC involve reimbursement of our fees. So if you hire our firm and we get you a bunch more money and we have a fee there for $20,000 or whatever it is, that's going to be part of the negotiation so that we say, hey, ITC, you're also paying this so that you come out completely whole. That is great nothing's great about this scenario, but it's great that this exists because many other states, and
I have five different state licensures. Many of their states do not have this fee statute that exists. So that is something you need to work to your advantage. And I said at the beginning of this presentation about leveraging your scenario. Hiring an attorney automatically leverages you because of this attorney fee statute. ITC knows that. ITC knows what the attorney fee statute. They know what would happen if they go to eminent domain. What happens is that they have to pay their attorneys. They have to pay your attorneys. They have to pay you for your land. So that leverages your situation against them. That prospect of them getting this process getting so much more expensive if they push and don't work with you, that's the leverage. That's how you get it back against them. So something to keep in mind, something I want to stress. Again, the contingency fee agreement, we like that for a lot of reasons. One, it allows landowners to hire us without coming out of pocket. So even though they're reimbursable in an hourly case, we'd still need, because if we're billing, we'd have to have some retainer up front. We'd have to bill, and yeah, it would eventually be reimbursable at the end. But in that instance, you'd still have to come out of pocket up front at first, and then get reimbursed at the end. In the contingency, our fee comes out at the end and is automatically reimbursed. So you're not coming out of pocket to hire us. You don't need to send me money to reserve our fees or to engage us. It's just as simple as signing a contract and letting us get to work. With that being said, we do have a landowner group that is growing by the day. I said we're approaching 20 parcels or so. We expect to represent quite a few more. And one other point in leveraging this scenario is that by working with a firm that represents a lot of folks, you get the leverage of everybody. If I go to ITC and say, hey, I represent 5 landowners, they're still going to respect me, of course, because that's not nothing, and we're qualified and we know what we're doing. But if I go to ITC and I say, hey, we represent half this line, then that leverage that comes from single representation spreads out to all the landowners. You're part of this, that power that I wield, that we wield as a large group, it trickles down to each landowner. The more folks we get, the more folks that sign up, the more leverage we have against ITC. But that's not to say this is not a class action. It's not a scenario where the settlement is negotiated and a lump sum and then distributed individually. Each landowner has their own individual case with their own individual concerns, needs, wants, concerns, etc. You have the authority over your settlement, no one else. So just something to keep in mind, something we want to relay to folks that are looking for representation. Okay. I am at the last slide. I'm going to stop talking because I'm sure people have questions. I'll say this. As soon as you receive an offer, you should hire an attorney. Until then, begin deciding what you want to do, considering a strategy, identify your priorities and goals to present to your attorney. Again, strength in numbers, the power of group. I just touched on that. We have the group. It exists and it's growing. If you have an offer and you're interested in a review, you can email it to my email address right there, jordan@swp-legal.com. You can call me at 317-575-9942. You can text me. That's my cell, 470-869-1383. You can text your offer. You can snap a picture of it. I know if you don't have it via email, snap a picture, send it to me. You can also fax. You fax it to that number as well, 317-575-9943. Again, we don't charge for this. You will not get a bill from me. You won't get a bill from me ever, even during representation, assuming you have a contingency fee agreement. So I won't wait too long. I apologize for that. I see there's a question. And I'll go to and we'll open it up for any other questions. The first question. So the question is, the family has land in the trust, and the trust says that the land can't be sold or divided, and that prevents ITC from getting an easement. Would adding the land to a trust with similar restrictions be a defense to prevent ITC from getting an easement? No, it wouldn't. Trusts get sued all the time in eminent domain for the acquisition of the easement. Your land is not exempt from acquisition just because it's in a trust. It might make it more difficult to convey the land as part of the trust provisions, meaning it might require, trustee consent or what have you. No land is exempt from eminent domain except for federal land. ITC can't acquire federal land, for example, because the federal land is supreme to the state level eminent domain authority of ITC. If it's private land, ITC has the ability to acquire via eminent domain. They will have the ability to acquire even if it's in a trust. Next question, how much are you seeing the offers in terms of dollars per acre? That entirely depends on the county where the property is located and what type of property it is. I'm seeing $6,000, $7,000, $8,000, $9,000, $10,000 an acre. It really depends on where the county is looking to, where the county is, what the offer is, and where the property is located. Have you chosen a firm to work with in Michigan under Pro Hoc Vice? Assuming you have to. That's a great question. Assuming we get to eminent domain, we will require Pro Hoc Vice admission. I should state it's not necessary that we'll require it because currently we are in the process of getting my associates getting the process of getting licensed in Michigan as submitted as bar application. We're hoping to get that response before litigation is initiated. And in that case, we wouldn't need Pro Hoc Vice because we would have licensure through our firm already. So it wouldn't require that. But if we do have it, we have a firm in mind, but we haven't gotten to that point. We have a firm that we work with. That's something that we already have squared away one way or the other, if it's even necessary, which we're hoping it's not going to be necessary. Does it make sense for ITC to make offers before the MPSC approves the project? If they make offers before the approval, they can then be rescinded if the MPC does not grant approval for the primary route. So what ITC is doing, they're making offers, but they're making what are referred to as option agreement offers. So they're not coming to you and saying, hey, we're going to give you $100,000 for your easement. They're saying, we're going to give you $10,000 for an easement. And then if we execute for an option to buy the easement in the future, and if they execute the option in the future, you get the other 90 in that scenario. So they're basically reserving the right to eventually acquire the easement through these offers. So that's why they're doing it that way, because it's a lot cheaper than going out and spending the full easement amount for something that is still has some, it's not, of course, fully approved. It's not hasn't been granted its authority yet. So they're doing this option, which is also a fairly common procedure method utilized by power lines utilities in anticipation of approval. So in the event it's not approved, they're not out of pocket the entirety of the easement amount where they can't build it. So does it make sense? For them, that's up to them. It's probably pennies for them to secure all these option agreements rather than buying the easements. It's an investment they're willing to make. It's a bet that they're willing to make. They're willing to gamble that and spend some money to get these options in the event that it is approved. So, it's something we see from utility projects quite a bit before approval is granted, offering options. I think it makes sense from their perspective. But it's just something. It's a method of acquiring land ahead of approval that some utilities do. In this case, ITC is doing. Your next question: if they make offers before the approval, then can they be rescinded if the MPC does not grant approval? So that's a good question. Let's say that a deal is struck between you and ITC, but the Public Service Commission ultimately rejects the proposal, says you can't build it. You're not going to be allowed to build this project, but you've already agreed. What does that mean? Well, it means you got paid for nothing, because if they can't build it,
they'll still own the easement, or they'll have the option to own the easement, assuming we're still dealing with options. You'll get the if they're still dealing options, you'll get that option money and for nothing, effectively. They won't execute it. They won't, they won't exercise their option because they don't have the right to build the project, and you get some money for nothing. So that would happen in that scenario. It wouldn't be rescinded. I mean, the rescinded is different because they're doing an option. They might make new offers after approval, but if it's ultimately rejected, and assuming you've agreed to it already, then they would just not exercise their option, and you got 10% of their easement offer and they can't build it, and they very unlikely to exercise their easement option. So next question: do you see ITC buy land versus purchase an easement only if they need substations? Generally, and that is the question is basically, are they gonna, if you see them buying, the full right to a land as opposed to just an easement, and they generally do not do that. It's something because they don't need the entirety of the land, and it's cheaper to just buy an easement in their view than buying the full right to the land, 100% ownership, as I mentioned earlier. So the only time they buy 100% ownership generally is if they need to put something like a physical structure that's going to permanently be there. Like a substation is a good example of when land is bought outright. Question: will the funds received be able to be used in a 1033 exchange? And that's a great question, and someone's done their research, because it's not a 1031, it's a 1033. So some of you might be familiar with the 1031 transfer, where you use the proceeds of a sale of property to then use towards the purchase of a like-kind property, and to avoid capital gains. That is a 1031. This would fall underneath a 1033. A 1033 is very similar to a 1031. The only difference is that it is an involuntary sale of land, meaning it's a sale made under threat of eminent domain. So it falls under the 1033 exchange. And 1033 is a little bit different. It has different, it's more favorable than 1031. And it's, first of all, I also want to say we're not tax attorneys, so we don't like to delve into that area too often. But you are correct. This would be subject to a 1033. If you'd want to use those proceeds to then buy like kind through a 1033 to avoid the capital gains, to avoid the tax, yes, that is something you can do because it's an involuntary exchange or a sale made under threat of involuntary exchange. Next question. There is testimony in the case that states that billions of dollars will be saved as a result of installing this line. Can those savings be used as a negotiation strategy to share the wealth in terms of a larger payment for the easement? This is a question we get a lot, that they're making money. So why don't you get some of that money? And I'll just say, from the way eminent domain works is that, like I said, you're entitled to just compensation. And just compensation is not anything you can think of that you should get paid for. The benefit that they are getting as a consequence of this acquisition is an example of something that's not something that you can consider an eminent domain. At eminent domain, you are entitled to the fair market value of your land. And that's basically what's the market value of your land. And that's what a willing buyer would pay a willing seller for your property. And the profit that they're generating, or the savings that they're generating, is not a valid consideration for more money, at least not at court. Now, you can say that in pre-condemnation negotiations. You can talk to ITC about that. You could tell them, hey, you're making all this money, we want X. It's not going to be a compelling argument for them because, as I said at the onset, everything, even though we're not at eminent domain, everything in these negotiations is viewed within that prism because they know that they have that authority. And they're only going to pay things that are compensable at eminent domain ultimately because they have that right. And they have ultimately, if you get to that point, that is the confines of what you're entitled to, what the law says. And the law does not allow for just compensation based on the profit that's generated by the entity. So there are many different ways to argue for more compensation that I touched on in my presentation. That is not one that again, you can say it, you can certainly try, but it's not going to move the needle. You're not going to instill any leverage on your side by bringing that up, because ITC knows that you're not going to get money for that down the road anyway. So they're not going to offer money premised on that. And a jury's not going to be able to hear it, and they're not going to hear it. If you restrict your discussions to something where you're going to get paid for that at court, just like you should get paid for it now, that's a more compelling argument. That's an argument that ITC has to listen to, because they'll eventually have to listen to it, or they'll have to argue it in front of a jury if it gets to that point. So it's important. That's why it's important to, it's not a matter of using magic words per se, but it's a matter of showing them that you know what your rights are, you know what the law says, you know what Michigan law allows for compensation recovery, and you're going to argue this now, and you're going to argue it tomorrow, and you're going to be able to argue it a year from now at court if you need to. That is a more compelling argument. That's something that ITC is more likely to listen to and more likely to give on, understanding that it's something they're going to have to contend with now, just like in the future. Okay, other questions? Last one, and thank you for all the questions, Peter. I appreciate it. How do you get paid for limitations in the easement that are not included in the easement price? Does having more restrictive terms in the easement reduce the compensation per acre? Well, how do I get paid? Our representation is twofold. You know, we don't get paid depending on how much easement language we add to your case. We just do that as part of our representation, and our fee, our contingent fee that we earn, that's what our services are. We get paid for our services. Our services are twofold: changing the easement, making sure the money is right. So we don't have a specific itemization or payment for something like that. It's just something that we do as part of our representation. And does having more restrictive terms in the easement reduce the compensation per acre? You know, that's a good question. And theoretically, you can make that argument, but they don't, and that would be an argument that they could make. I've never seen a utility lower their price per acre based on a more restrictive easement. When they come to you with the offer is the offer. And it's also usually the lowest point that they're ever going to be. So, you know, you could argue that, yeah, we were going to offer this for this easement, and now we're offering this minus 1,000 for a more restrictive easement. I've never seen that happen. And it wouldn't be something that we would even allow to happen. It would be a non-starter discussion for our purposes. That, you know, it's not something that we would allow to happen. It's not something that I've personally seen happen. Again, you could see it theoretically, but I haven't seen it. And I certainly haven't seen it in our negotiations thus far with ITC. But good question. Other questions? Okay. Well, I'm not seeing any other questions. Which that's fine. Great. If you have questions that you didn't think of and you think of down the road, not a problem. Shoot me a text, shoot me an email. Happy to answer questions. I'm not going to bill. You're not going to get an invoice from me for this stuff. Happy to answer any questions you guys might have. So, okay. It's been much longer than I thought it'd be, and I apologize for that. Thank you for stopping by. I appreciate your attentiveness. I appreciate your time. Please contact with questions. Let me know if you're interested in representation. And also, have a good weekend.